Good afternoon, everyone. So it's my job to challenge some of the myths around data breach and actually to share a little bit about what's coming down the pipeline in terms of legislation in Europe. So what are the myths around data breach? And I know that you've looked at a lot of the technical issues around breach this morning, but here were some that I've come across or that people I know have come across. The first one is, let me just... The first one is that data breach is an IT project. Have you heard that one before? Data breach risk, data breach mitigation are all IT projects. Hackers only target large retailers. Privacy and security officers have this covered. Technology makes us compliant. Technology is the best protection against hackers. Our employees know what to do. IT policies are enough to address breach mitigation. Sound familiar? What about this one? We don't need to worry. We don't have breach notification laws in Europe. True or false? So my practice focuses on data protection and cyber risk. I'm not a technical person, I'm a lawyer. And in our team, we have helped clients with over 1,200 data breach incidents, many of them global, a great number of them in the US. But what I can tell you from this experience is that no two breaches are the same, and the ways in which we help clients manage this risk really differs from one incident to another. I think, too, the US experience is very different to our experience in Europe. Of the bigger incidents that I've been involved in, and actually the largest one involved 78 jurisdictions, one company with an incident that impacted it in 78 jurisdictions, we actually adopted a strategy for managing this incident that involved us taking different decisions in different jurisdictions in terms of notification, both to regulators and also to individuals. And actually, the way in which we managed that incident required very careful coordination on a global basis. But at the end of the day, and we did tell regulators in some jurisdictions, and we told customers of this company, at the end of the day, this incident hit the news headlines in one jurisdiction, 1 out of 78. So it is possible to manage these incidents and to keep them under the radar. And I think increasingly, these are the kinds of skills and these are the kinds of approaches, global management of these issues, that we are going to need, including here in Europe, because the data protection laws are changing. Now, we've got a couple of questions that are going to go up on the slide here, and I'd just ask you to click your response. The first one is, and I apologize if they're slightly similar to some of the questions you were asked this morning, but the first one is, have you had a security breach incident in the last year? And what does that look like? Okay, so 63% of you have said yes. What just really intrigues me actually are the 20% who said they don't know, and indeed the 20% who say no. As you heard this morning, there are really two kinds of companies, those who know they've been breached and those who have yet to find out that they've been breached. So that's an interesting number. Let's look at the second question. Do you have a security breach notification procedure? Okay, so 60% do, and a very definite 30% do not. This is really a key part of your preparation for dealing with a cyber risk incident. Let's go on to the third question. Is your senior leadership aware of your breach notification procedure? And so that's interesting, isn't it? Only about half, just under half, can actually say that their senior leadership is aware of this procedure. We'll come back to that point, and let's just move on to the final question. Are you prepared for mandatory breach notification under the new data protection regulation? So it's a very honest 55% saying no, and actually just a quarter of people feel that they are ready for what's coming down the pipeline. That's what we're going to talk about. Let's talk about what is coming down the pipeline in Europe on the legislative front. So I'm going to focus on the General Data Protection Regulation. I'm not going to bore you with lots of law, but we'll talk around what some of the issues are, and we'll actually talk about what you can do now to prepare for what is coming down the pipeline. And just to begin, I would say that in general terms in Europe, we do not have mandatory breach notification laws. There are some exceptions to that. There are exceptions in 1 or 2 member states. There are some exceptions that operate on a sector-by-sector basis, but for the most part, we don't have mandatory breach notification laws. So this is a point of difference between Europe and the US. And indeed, in the US, people will tell you that one of the reasons cybersecurity issues really come to the fore is because you have to tell others about them. You have to tell regulators and you have to tell your customers. So without the notification, the scene is very different. Let's look at the European Data Protection Regulation. Now, I know that you know about it because it was mentioned in the introduction, but what does it actually mean and where is it up to? Well, this has been a very lengthy process. So if you haven't heard about it yet, you might be interested to know that it's actually been discussed since before 2012. And we are now some way down that path. The highlighted boxes there, we are now in the trilogue in Europe. So the Commission, the Parliament and the Council are sitting round a table, actually sitting round a table right now, talking about some of these new provisions that will form our European data protection law. It's significant that this is going to take the form of a regulation. At the moment, we have a data protection directive. And when you have a directive, it needs to be implemented into the national law of each member state for it to take effect. And as a result of that, we have lots of different laws across Europe that govern data protection and aspects of cybersecurity. The regulation will harmonize a lot of our data protection law. Not completely, but to a very significant extent. The other thing to note is that when you look to the timeline and look and see which sorts of issues are being discussed, actually the core issues are being discussed right now. And some of those issues involve a real tightening up of obligations on companies and on the rights of individuals. And we'll look at that in a little more detail. This is a great slide to take a picture of or to take away from this conference, because if you have to explain internally why this data protection regulation is important, this slide gives you a pretty good starting point. It's a good summary of some of the key aspects that will change. And one of the key themes you will see is breach notification. I've popped it right in the center there under the heading increased obligations. But before we get to that, these are some other things that it's worth knowing. The first one is, and I've touched on this a little bit, there will be harmonized laws across Europe. So this means that there will be a much less national divergence. If you're dealing with a data incident and you're thinking about your notification obligations, the chances are that you will have to take the same approach across all of the European jurisdictions. The second point, wider scope. And this is really crucial, I think. This is a big change. This law will not just apply to companies using technology based in Europe to process personal data. Instead, this law is going to apply to companies that process the data about European citizens. So it will also catch companies based outside of Europe that target their services at European citizens. So the scope is the territorial scope is much broader than our current regime. It's also important to note that there are obligations on both controllers and processors. Now, if you're a service provider sitting in the audience, you probably focus on data protection from a security perspective. You've probably got obligations in your contract that set out what it is that you can and can't do with the personal data you're processing. But you will not have statutory obligations that can lead to fines and sanctions from the regulator if you breach those obligations. Instead, you're likely to be subject to contractual damages if you breach your obligations. Now, that will change, and this is a really significant change. So what will happen is that controllers and processors will have obligations, including in relation to security, including in relation to breach reporting, and most significantly, the regulators will be able to fine processors as well as controllers. The fines that are currently being discussed are somewhere between 2 and 5% of global revenue. It could be a very big number. Okay, increased obligations. Now, this is where I've put the data breach notification obligation. So we don't quite know exactly what the detail will be, but it is clear that this obligation will be in the new regulation. So there will be an obligation to report breaches to regulators and probably also to individuals. Strengthened rights of individuals and increased enforcement, I'm just going to touch on together. One of the other big differences between breach scenarios here in Europe and breach scenarios in the US is that, unlike in the US, in Europe, individuals don't tend to complain. They don't tend to bring lawsuits seeking damages. They don't tend to group together and bring a class action. And the courts don't tend to award damages. That is about to change. And so we will move closer to the US context or to the US scenario. In Europe, we will have something that will be akin to a class action. Regulators will need to deal with complaints from individuals, and the courts may be able to award damages to individuals as well. So we are looking at a very, very different regulatory environment, and I think this will have a significant impact on the way in which breaches play out currently in Europe. Let's just look at data breach reporting. So what is a breach? I mean, that is probably the first question to focus on. What is a data breach? It will be defined in the legislation. It won't just be a breach of security, but it will be a breach that involves any kind of accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data. So it focuses very much on personal data. Your systems might contain other kinds of data as well, but if the data are personal and those data are compromised, then you're likely to be within this definition. And as I said before, comparing the now and the future, and the little red dot indicates that the position is going to be tougher. We don't have these general reporting obligations in Europe currently, save for some particular jurisdictions or voluntary regimes in others, like in the UK. But what we will move across to is a general reporting obligation, both to regulators and to the individuals who are affected by the incident. So what does that mean? What actions will companies need to take? What will need to happen if you discover a breach? Well, I think the first thing to note is that there is this obligation to report to the regulator who is going to have much more significant powers to fine and to sanction companies that breach obligations like the obligation to keep data secure. So in terms of reporting to the regulator, I think one of the really tough things is that there's a very short window for notifying the regulator. In one of the drafts, and it was the first draft actually, the timing is 24 hours after discovering the incident. Now, there's been a lot of discussion this morning about mobilizing breach response teams and about those first steps to take when you discover a breach. But how many of us would be ready to report to a regulator within 24 hours? How much would we know after 24 hours? Probably not very much. The Council has proposed a more realistic timeframe of 72 hours, but even in 72 hours after discovering the incident, it's unlikely that you're going to be ready to report to the regulator. And as we've just heard, there may be tactical reasons as to why you want to be very careful about letting on that you've actually had an incident. You might not want to take steps immediately to address the incident, but yet on the other hand, you may have an obligation to report to a regulator. So these issues will need to be thought through. There will be ways of accommodating both, but they will need to be done carefully, and companies need to be prepared for these responses. They need to think through in advance how they're going to manage these conflicting objectives. So the second point there, conditions. So it may be the case that you don't have to report every single breach, but actually that you report the breaches that have a significant impact on individuals. And the texts, again, are slightly different on this point, but the focus is very much on the harm to individuals. So individuals are at the heart of this, and companies are going to have to assess whether the incident is likely to cause harm to an individual. That can be quite a difficult issue of judgment to make within 24 hours or 72 hours. In terms of what you need to report, this is pretty detailed actually. So the regulators do want details. They want to know what the breach is about, what kind of breach is it, how did it happen? I've just lost the battery out of this. How did the breach happen? What have you done to remediate it? Is there a contact point for dealing with the breach? What are you doing to mitigate the possible adverse impacts of it? So how are you safeguarding individuals? And then what additional steps are you going to take really to tile this down and ensure that the data are safe once again? Now this is extremely important actually, because in one of the texts, companies can mitigate the impact of a breach after it has occurred and actually expect the regulator to take that into account when it comes to determining sanctions, when it comes to assessing whether the company has actually sought to comply with the legislation. So this is something that then needs to be reflected into the company's breach management policies and breach response process. This mitigation is a crucial action, and it needs to be documented. Then there needs to be proper evidence of the steps that the company has taken to understand what the likely impact of the breach could be on individuals, and then to take steps to try and mitigate that impact, so that you then have the evidence to put to the regulator. What about reporting breaches to individuals? So again, the timing is tight. It's without undue delay. We don't have the specified timeframes, but without undue delay is pretty promptly. There is likely to be some kind of risk threshold here, some kind of harm consideration. So if there is harm to individuals, then the expectation will be that individuals are told about the breach. Again, there needs to be enough information about the breach itself, what happened, who to contact, and what you can do to protect yourself. Now, many companies will follow this kind of process and disclose that kind of information already when they deal with breaches, including in the UK, where the Information Commissioner expects companies to tell people about a breach if their data are going to be harmed. But it will become mandatory under this proposed regulation. And the exemption at the bottom there is also important to note. It looks like there will be a carve-out if the data can be encrypted or de-identified in some way, so that actually they're not going to be that useful to the thief. So what does this mean for business? Well, I think at one level it means that companies really need to think quite carefully about their existing information security procedures. How do you currently manage your breach process? What will you need to do to change that process so that you identify the incident promptly and so that you then have a process that almost swings into action automatically to take the right steps to make sure the right people are involved, that they mitigate the loss, they close it down, mitigate the loss, tell the right people at the right time, but yet don't go public too early. So I think it's a good time if you need that prompt to tell your senior management or to give them a reason to engage in this process of reassessing your breach procedure, the regulation is a good time and is a good prompt to have that conversation. There needs to be a proper data breach response plan. We've talked about breach response plans this morning. Breach response plans are certainly helpful, but they are not sort of the be-all and end-all. They're only as effective if they have been rehearsed. So breach response plans need to live, they need to be integrated, they need to be implemented into your team so that people understand what it is that they need to do as and when an incident is discovered. Think about encryption and other steps that you can take to ensure that if data are accessed, they're not actually able to be used very easily. Think about the cost of dealing with an incident. The cost can be very significant. Think about all of the different actors that need to play their part in containing an incident. Think about the preparation that you need to undertake in order to ensure that your incident response team is ready to swing into action. Think about the cost of making sure your board and your senior leadership are aware of what these incidents are about and are prepared to respond. All of these actions are really good preparatory steps, but all of them have a cost associated with them. And again, if you need more budget to enable you to cover off these issues now and the imminent conclusion of the legislative process in Europe is a really good time to make your case. And then the final point is that just as data flow very internationally, data breach obligations around the globe are really not harmonized at all, but we will see greater harmonization in Europe, which I think is going to make it easier to manage in many respects from a pan-European perspective. Okay, so here are the sanctions. This is what happens if these incidents come to light under the new regulation, and these are some of the powers that the regulator will have. So the first point is that individuals will have greater powers to seek a judicial remedy, unlike the current position where most individuals actually just don't bother. I think one point to note is the last bullet point on the bottom right of the slide there. Individuals claiming compensation. I said earlier that individuals don't tend to do this in a European context. It's actually really hard to demonstrate that you've suffered loss following a breach. And that's why in the US, very few of the class actions have been that successful. There are many, many of them, but very few of them have actually resulted in payouts to individuals. That's changing a little bit. But what we have in Europe in the UK at the moment, which is changing this already, and aside from the regulation, is an important judgment delivered by the Court of Appeal earlier this year. It's a Google case. It involves Vidal Hall, Judith Vidal Hall suing Google. And there's a key interim judgment there that allows the court to award damages for non-financial loss. And often, in a breach context, the loss is not financial. So it's distress or it's other inconvenience, but it's not financial loss. Now, that case is going on appeal to the Supreme Court, so it is a point to be watched. But it is interesting to see that even in our European context, we are seeing challenges as to what sorts of loss and irritation people can actually expect to be compensated for. All right, sanctions, and I've touched on this a little bit already. The sanctions are going to be significant. Whether they are 2% of your global revenue or 5% of your global revenue, it could be a big number. And remember, the regulator will be looking at the provisions of the legislation that required you to keep the data safe in the first place. You will be able to mitigate, so when the court comes to consider what kind of sanction is appropriate, steps that you've been able to take to mitigate, to encrypt, to de-identify the data will be taken into account in deciding what the appropriate sanction is. But importantly, these sanctions will apply to both the service providers and to the customers. So those who actually own and control the data and those who are simply processing it on their behalf. And so here, from a business perspective as well, it's important that this is the sanctions and fines are taken into account in preparing your patch, particularly as steps that you take to mitigate the loss may be taken into account in deciding what kind of sanctions to award. I wanted to mention just very briefly, as I finish, the Network and Information Security Directive. I suspect that this is one you're more familiar with rather than the Data Protection Directive. It's at the same stage as the Data Protection Directive in that it's in the trilogue in Europe. This imposes a national framework for network information security. It encourages or imposes a framework for encouraging cooperation amongst regulatory authorities to share information, and it will also involve early warnings and notification of incidents, and these obligations will be imposed on providers of critical infrastructure and information society services. So that's just a very brief overview of what that is about. I think from a business perspective, the key thing there is just to be aware that in this context, the authorities are likely to be able to come in and conduct audits to see how people are complying with this and taking it into account. Again, the regulators will be expecting to see policies and procedures that indicate, that demonstrate that your organisation is prepared to deal with these incidents. So what does that mean going forward? So it actually means preparing for this ahead of time. And I know that this reflects a little bit of what you've heard this morning. It also reflects, I think, a pretty sort of standard gap analysis approach to these issues. But actually the key thing is really to understand where your vulnerable data are, to know what those vulnerable data are and to know where they are, to understand where that information sits, with whom it is shared. So many of the big breaches that we have seen have involved the data being accessed by vendors, data being processed by vendors. Think of Target. It's a very common scenario. It's the weaknesses in the vendor system. Then I think we need to be thoughtful about these proposed changes in the legal framework. Mandatory breach reporting will come. It's in the legislation. The finer details are still being ironed out, but there is no suggestion that it will be removed. So mandatory breach reporting. And then I think in light of that, there needs to be a thoughtful approach to what you already have in place. You may have some kind of breach reporting protocol or process or remediation plan or procedure or policy already in place. Dig it out, dust it off, have a look at it, and think about it in the context of what is proposed. Is it going to be sufficient, or do you need to update it? And who needs to know about it? Do your executives know about it? It's important that senior leadership of your organisation is aware of these changes, is aware of the risk, and is part of your initiative to help address and manage that risk. And then finally, and I don't know whether we'll have time for questions, but finally, I would just say, in terms of myths, where we started this conversation, debunking the myths, you heard the myths that I rattled off to start with, but actually we paused then, if you recall, on this question of whether or not we have mandatory breach notification laws in Europe. As you will have seen, we have a small patchwork of current laws, but actually we will all be in an environment soon where there will be mandatory breach notification, and it's important to be prepared for that. Any questions?